Welcome to Business SOS podcast. This is episode number 65 of Business SOS. This is Rich Sierra. I'm president of the Florida Small Business Legal Center here in Boca Raton, Florida. Every week I host this podcast, and sometimes I bring guests and talk about legal issues affecting small business owners, and hope this information that I'm providing to you is helpful to you. Today I'm going to revisit a topic that I did last year, and because the deadline is coming up and it's going to affect pretty much most businesses in the United States. And if you listen to me, you have a small business, it's very likely this will affect you as well. So today I'm going to talk about the beneficial ownership information reporting requirements. And I'm getting the information directly from the Small Entity Compliance Guide, and I'm just showing it to the camera just for the benefit of those who are watching this via YouTube or YouTube channel. We'll have a link to this document directly from FinCEN, from the Financial Crimes Enforcement Network, from the U.S. Department of Treasury. I have the link to the document directly on the show notes and also on the YouTube channel as well, for those of you who would like to download the document. So what is the beneficial ownership information? Basically, most small businesses in the United States have to report who the beneficial owners, who the owners of the company are, and identify the actual owners of the company, who actually makes the decision. And I'm going to go into more details now shortly, but also you have to provide their IDs. You got to provide some valid identification form that will be stored with FinCEN, with the Department of Treasury. There's a pending lawsuit, actually, I believe in Arizona, which only that they're trying to stop this on the basis of privacy, but they were able to stop it only to the people who filed the lawsuit. Everybody else has to comply, and there's some deadlines that are coming up that I want to share with you, but also there's some significant penalties for not complying with the deadline. In fact, yesterday I actually did my beneficial ownership information report, and it's pretty straightforward process. It took me like 10 minutes to do. I kind of knew what I was doing, simply because I've been preparing for this podcast and I did this before. But for somebody that perhaps is not familiar on how to do it, there are instructions, and also there's services that are providing that as well. But if you take a little bit of time, you'll be able to do this yourself as well. So why do you have to report, and who has to report? Let's go over that first of all. And I'm just going to go, you bear with me, I'm going to go through some of these strictly from the handouts and my highlights as well, and I'm going to read some portions as well. And basically what it says, who is a beneficial owner? A beneficial owner is an individual who owns or controls at least 25% of a company or has substantial control over the company. And a company applicant is an individual who directly files or is primarily responsible for the filing of the document that creates or registers the company. So just as I said before, I mean, a beneficial owner, if you're in a small business, you have your president of the company, your shareholder, and anyone who is in that company who owns at least 25% of that company, it is considered a beneficial owner. You also have situations where you have the owners, but then you have a manager of the company. The manager makes some significant decisions like hiring or firing, makes some decisions like expenditures, and there's some more definitions here. That individual will have to be reported also as beneficial owner of the company as well. If somebody owns, say, 10% of the company, for example, and is a passive investor and does not really participate in the day-to-day activities of the company, most likely that individual will not have to be does not have to be reported as a beneficial owner of the company. And there's some, before I go into the details of who has to report and what information you got to provide, I want to make sure within the first few minutes of the podcast you realize you know about the deadlines as opposed to doing it at the end. So reporting companies, the question is, when do I need to file a report? The reports were starting to be accepted for beginning of January 1st, 2024. Reporting companies created or registered to do business before January 1st, 2024 will have until January 1st, 2025 to file their initial, what is called BOI reports. So we're already in August. The deadline is coming up. So that's the reason I wanted to revisit this. I believe I did this in March of this year. So I wanted to at least revisit the issue to make sure, put it kind of in the front of the agenda. This is something you have to do before the end of the year. Don't procrastinate. Just get it done. It won't take you too long to do it. And I'll tell you what website to go to. For companies that were created, reporting companies created or registered on or after January 1st, 2024, and before January 1st, 2025, have 90 calendar days after receiving actual or public notice that their company's creation or registration is effective to file their annual BOI reports. What that means, so say in this year you created a LLC, you created a corporation. In Florida, say you incorporated in SunBiz, and it shows up. From that date of incorporation, you have 90 days to submit your BOI report. So that I want you to make sure of those deadlines. So there are two deadlines that I want you to, three of them, but this one really does not apply as of now. Reporting companies created or registered on or after January 1st, 2025 will have 30 calendar days from actual or public notice that the company's creation or registration is effective to file their initial BOI report. So let's not worry about 2025. From your perspective, if you're listening to me, you have a business was created before January 1st, 2024, you have until January 1st, 2025 to file your BOI report. So do it sooner rather than later. Don't wait till the last minute. And again, it doesn't cost you anything. You just go ahead and submit the information you have to provide. If you created a company this year, you incorporated it, and if you have not done it, just go ahead and get it done. Go ahead and file your BOI report. You have 90 days from the date of incorporation. If it's late, just go ahead and file it anyway. It's better to go ahead and get it filed because a lot of people are just not familiar with this, and it might not get it done on time. Just go ahead and get it filed. Where can you get this information? More information is in the website is www.fincen.gov/BOI. Again, it's fincen.gov/BOI. So who has to report? Who's a beneficial owner? First of all, who's a reporting company? And I'm going straight from the manual. A reporting company is a corporation. The answer is yes. If it's an LLC, it's a domestic company. Yes, you have to report. If you filed the Articles of Incorporation with Secretary of State, yes, you have to report. Who does not have to report? We'll go through some exemptions. There are a number of companies that are not exempt from filing. And I'm going to go through the list. They have 23 different entities here that are not required to report. One is a securities reporting issuer, a governmental authority, a bank, a credit union, depository institution holding money services businesses, those are people that cash checks, brokers or dealers in securities exchange or clearing agency, other Exchange Act registered entity, an investment company or investment advisor, a venture capital fund advisor, an insurance company, a state licensed insurance producer, a Commodity Exchange Act registered entity, an accounting firm does not have to report, a public entity, a public utility, I apologize for that, financial market utility, a pooled investment vehicle, a tax-exempt entity. This is interesting. So if you have a 501c3, you have a nonprofit, according to this, you do not have to report. An entity assisting a tax-exempt entity, I guess in the same category. Large operating company, I'll go over that in more detail because you're listening to me, you might have a large operating company that might be exempt, that is exempt from filing the BOI report. I'll go over that in more detail in a few minutes. A subsidiary of certain exempt entities, inactive entities. So if your company, it is inactive or is dissolved, then you don't have to report. And there's no definition of what inactive is. To be safe, the company's active on the, as an active company in the Secretary of State's website, just consider it an active company. If it's dissolved, then it's an inactive company. Just because you're not conducting business may not consider inactive, quote unquote, for the purposes of filing a BOI report. So I want you to be aware of that and don't just take this, the word inactive, and say, well, I'm not doing business, so I'm not going to report. You might have to report. So just be safe than sorry, better safe than sorry, and get that reporting in if you need to. So let me go into more detail about the operating company. So the operating company exemption, and this is the large operating company exemption, is important because you might qualify, you might be in this category. So let's go over that. And then according to the BOI Information Reporting Requirements Manual, the Small Entity Compliance Guide, they have 6 different criterias that they require in order for the company be exempt from filing the BOI report. So let's go over that. And I'm going to kind of briefly go over the list, not read everything. So one of the criteria is the entity employs more than 20 full-time employees. And basically full-time employees is employees that are working for 40 hours a week in a 5-day work week. So in general, full-time employees means with respect to calendar month, an employee who is employed an average of at least, and I digress here, an average of at least 30 hours of service per week with an employer. So if you have 20 employees and they're working at least 30 hours a week, you meet one criteria. More than 20 full-time employees in the entity are employees in the United States. So the employees that you have must be working in the United States, at least 20 of them. So you have more than 20 employees, you have 40, these 20 have to be working in the United States. The entity has an operating presence at a physical office within the United States. And what it means is operating presence at the physical office with the United States means that the entity regularly conducts its business at a physical location in the United States, and the entity owns or leases, and that is physically distinct from a place of business and any other affiliated entity. So you have your business, you have a lease, you own your building. That is in a criteria as well. The entity filed a federal income tax or information return for the previous year demonstrating more than $5 million in gross receipts or sales. And then it talks about affiliated group or corporations, but that's not something we're going to talk about right now. The entity reported greater than $5 million amount of escrow receipts and sales in the Form 1120, Consolidated Form 1120S. So if you have $5 million in gross sales receipts or $5 million in gross receipts or sales and reported that as part of your tax returns, you also, that's a criteria that you have to meet as well. When the gross receipts or sales from sources outside the United States as determined under the federal income tax principle are excluded from the entity's amount of gross receipts or sales, the amount remains greater than $5 million. So if you have your company does business overseas, whatever revenue you generate from that particular overseas part of the business, that's deducted. You still have to have a net set receipts of $5 million. So I will agree, this is not very clear. So if you're you have questions about your specific situation, whether or not you have an operating company, whether you would qualify, my advice is to talk to your CPA, your attorney, and they can basically go into more detail as to your particular situation. But I wanted to at least illustrate for you that, make the point that some companies are exempt. And if you're in that situation that you have over 20 employees, you might not have to report it. But to err on the side of caution, my suggestion is to get the advice necessary to make sure that you comply with the law. And a question that is important to address is that what happens if your company does not report BOI in the required time frame? And there's some penalties for not doing so. So there's a penalty provision here, and I wanted to talk about that. So I'm just going to quote specifically from the actual document just to make sure that that I don't tell you the wrong information. And it states here the willful failure to report complete or updated beneficial ownership information to FinCEN, or the willful provision or attempt to provide false information or fraudulent beneficial ownership information may result in a civil or criminal penalty, including civil penalties up to $500 for each day that the violation continues, or criminal penalties including imprisonment for up to 2 years and/or a fine up to $10,000. Senior officers of an entity that failed to file the required BOI report may be held accountable for that failure. What this means is that even, you usually have, as a corporate officer, you have something called a corporate veil that protects you from personal liability for corporate acts. In this particular case, what they're saying is that the senior officers of the company could be personally liable for failing to file this report. So this is serious, this is important, and I want to stress upon you, and again, for something this simple, it's just not worth the risk of having some type of fine be issued at $500 per day for not filing something that takes around 10, 15 minutes the most. So I just want to, and again, this won't cost you anything to do that unless you hire somebody to do it for you, and that is fine. Just want to, make that point to you. So it's important to you meet that deadline. And, and I wanted to make sure I put this at the beginning of the podcast. So that way, if there's any takeaway here, go to the FinCEN website, and I'll give the website again, so you can get it done today. If you're listening to the podcast, it's www.fincen.gov. And you go to that website, you'll see right in the homepage, information, file your beneficial ownership information. It is there. You can follow the prompt. You will need some documents, and I'll go over that with you, what you need to file that report. But again, it's not worth the risk for not doing it. Just get it done. So I want to go into who's a beneficial owner of my company. There are going to be a lot of questions to this about who is required, who you have to report. You have partners, you have people that own interest in the business. So we're going to start very simple here. So if you're sole proprietor, you're the only member or owner of the company, you're the only one that has to report. So that's simple. Just go ahead and just get your information, go ahead and submit it, and you're done, okay? What happens if you have a number of partners in the same company? It's not common in LLC and corporations. You have a number of partners. They may have different ownership interests in the company. So as a rule of thumb, those who have anything over 25% of the company's ownership, and that can easily be reflected through your bylaws, shareholders agreement, and also on your K-1 reports. Your accountant, when does the KY reports and the federal tax returns, assessed what ownership interest each member has. So that you'll get that information. Also, you will know who owns what in your company. So those individuals will have to be listed in the beneficial ownership information report. If somebody has a silent partner or has maybe anything less than 25%, then those individuals don't have to be reported. But you have to make sure that that is actually accurate. Obviously, anyone at 5-10%, you're not going to have that threshold. But just to be clear, when you submit the report, you're doing it under oath. So you got to be accurate, and you can also download a form and do a draft before you actually submit it online, just to be on the safe side. So you can also do that as well. What is substantial control? And I think it's important to talk about this as well. They have substantial control indicators. And they define here, an individual exercises substantial control over a reporting company if the individual meets any of the 4 general criteria. The individual is a senior officer, number 1. Number 2, the individual has authority to appoint or remove certain officers or a majority of directors of the reporting company. 3, the individual is an important decision maker. Or 4, the individual has any other form of substantial control over the reporting company. So, and there's a chart here in page 17 in this report, and I want to just show it for our YouTube viewers. And so it's good to download this form as well. If you want more information, I'll put the link up. So a senior officer is any individual holding the position or exercising the authority of a president, chief financial officer, general counsel, chief executive officer, chief operating officer, or any other officer, regardless of official title, who performs similar functions as these officers. So it's important to know that if you have a company, somebody has a title of any of these titles, very likely they will have to report. You'll have to basically list them there as a beneficial owner, regardless of whether or not this individual owns any shares in your company. So I just want you to be aware of that. Just because somebody can have authority over the company or authority over a function of the company, but they may not necessarily actually have ownership in the company. So I want to make you aware of that. Appointment or removal authority. An individual with the ability to appoint or remove any senior officer or a majority of the board of directors or similar body. So you can have an owner who has authority to remove the CEO, the CFO. That individual is considered a beneficial owner that has to be reported. Important decision maker. Any individual who determines, this is straight from the manual, any individual who directs, determines, or has substantial influence over important decisions made by the reporting company, including decisions regarding the reporting company's business, such as nature, scope, attributes of the business, the selection or termination of business lines, ventures, geographic focus, the entry into a termination of the fulfillment and non-fulfillment of significant contracts. This is important. I want to stop here for a second, okay? So you have a general manager in your company, and this individual is authorized to sign contracts for your company. Very likely this individual will be considered an important decision maker for the purposes of the BOI report. The person might not be an owner, but the person might have the ability to sign contracts on your company's behalf. Yes, that person will be an important decision maker, and that person has to be reported, included in the BOI report. Finances. Sale, lease, mortgage, or other transfers of any principal assets. Major expenditures or investments, issuance of any equity, incurrence of any significant debt, approval of the operating budget. Most likely these really fall within the owner, but if somebody else has the authority to do these, they're going to be considered you got to include them an important decision maker. Structure, reorganization, discussion, dissolution or merger, amendments of any substantial governance documents of the reporting company, including articles of incorporation or similar formation documents, bylaws, and significant policies or procedures. In my experience, this really falls within the owners or the shareholders. Doesn't fall within someone who does not own the company, but they include it there. And there's also one more thing here. Just in the case this was not thorough enough, then you have a catch-all provision. Any other form of substantial control over the reporting company. Control exercised in new and unique ways that can still be substantial. For example, flexible corporate structures may have different indications of control than the indicators included here. So in essence, they're saying anybody who has control of the company and has some decision making, even if they were not listed here, they still can consider a person has substantial control. And I'll give you an example. There's some cases that I've dealt with, but I've been trying to give you an example that is very broad in general. So say, for example, you have a husband and wife team working, but for purposes of obtaining government contracts, this couple decided to have the wife to be basically the president of the company, be the only owner, in order to have that 51% majority to be an all women-owned business, to be able to get some bids and government contracts that are specifically, available to women owners. So it is sometimes they have situations where the husband, basically, it is the person who makes the decisions on the business. He's the operating manager. He's the one that signs contracts. He's the face of the company for the purposes of working with customers, vendors, and anybody else. But on paper, it is the wife that owns the business. But he's not anywhere in the corporate documents, because when they do the requirements, the audit or the application, the wife is the one that submits the documents. She signs it as a woman-owned business, but he's the one that really works behind the scenes. It's very common. I'm not passing judgment. There's nothing wrong with that. I'm just telling you that for the purposes of the BOI report, he would have to be included there because he has substantial control of the company. He's an important decision maker. And even though he's not listed in the corporate documents, and he may not own, on paper, any shares in the company. So I just want to make that distinction. And again, there's different situations for many different reasons that somebody may not be listed in the corporate documents, but they kind of run the company, while someone else is listed as the owner or the person really behind the scenes, the person in charge. So I just want to kind of make you aware of that and every situation is different. And if you have any questions regarding the BOI report, again, check with your CPA, your accountant, or you can call, your business attorney as well. Of course, you can call us and we'll try to assist you as well on that matter. This is actually important. Who has ownership interest? And there are a number of ways that, and this is kind of not a very clear section, but I want to do my best to explain it to you. The simple one is that who owns the company? Anybody who has shares in the companies is an owner of the company. Could be between 1% to 100%, but for the purpose of the BOI report, you got to report anybody who has over 25% of the company. Now, there are situations sometimes that somebody may not own a company, and you have a key employee where you basically have a profit sharing plan, or you share some of the profits, or you have a joint venture which somebody gets a share or whatever the sales coming in. So they talk about here capital profit interest, any interest in the assets or profits of a company organized as an LLC which has similar stock in a corporation and referred to as a unit. So if a company has ownership interest in an LLC or a company, and we call it membership units in the case of a LLC, that individual has to be listed as well as a beneficial owner of the company. And they talk here about convertible instruments. Any instrument are convertible into equity, stock, voting rights, or capital or profit interest. Whether or not anything needs to be paid to exercise the conversion, then the related items are also ownership interest. Any future or any convertible instrument, any warrants or right to purchase, sell, subscribe to a share of interest, equity, stock, or voting rights, or capital, profit interest, even such warrant or right is a debt. So anything in the future that can be converted into ownership, that has to be reported as well. And they go into option or privilege, any put, call, straddle, or other option or privilege, or buying or selling equity, stock, or voting rights, capital, profit interest, or convertible instruments, except if the option or privilege is created and held by others without the knowledge or involvement of the reporting company. Not sure about that exception, but any type of future option that a person might exercise is also may consider a beneficial owner. And of course, they have one more, just to be safe that they include it. It's a catch-all provision. Any other instrument, contract, arrangement, understanding, relationship, mechanism used to establish ownership. So this is, if you don't have any of these and you said you have some type of arrangement, as they call it here, that somebody's going to own a certain part of the company in the future, or they own part of the company even though they're not on paper, they're a beneficial owner. So what FinCEN is doing is creating kind of a broad umbrella to make sure that anybody who has a decision-making authority within your company, it is reported and enlisted into the beneficial ownership report. And they talk here, what steps can I take to identify my company's beneficial owners? And I just give you a few examples. Direct ways to exercise substantial control over a reporting company are board representation, ownership or control, a majority of voting power, rights associated with financing or interest. So, again, this is not, the guide is not very clear, but just looking back and using some common sense here, if you have someone who has decision-making authority over your company besides you, that individual will have to be reported into as a beneficial owner. As somebody owns shares in your company over 25%, the person will have to be reported as a beneficial owner. And somebody, say a manager in your company who has some decision-making authority, regardless of whether or not this individual owns shares or ownership in your company, that individual will have to be reported. Okay, so briefly, what information do you have to provide? So I'm going to jump to that very quickly. Let's see here. I already did this one. Okay. Information you got to provide. The first thing you got to do is have your, obviously, full legal name of the company. That's the way you incorporate it. Any trade names, any DBAs that you're using, trademarks that you're using the company, that you're using to promote your company in terms of your company name, that's to be reported too. Your complete address, and each beneficial owner and company applicant. There's two distinctions here. Beneficial owner is the one that has control over the company or some decision-making authority in the company, as we talked about it before. The applicant is the one that assists you, say, help you incorporate. Like, for example, if we created your company this year, we're considered an applicant, and then we got to provide information to you, in this case, the FinCEN number, in order for you to say, okay, this person created my company. For companies that were created, that were doing business before, created January 1st, 2024, you don't have to do it. So only the applicant is after January 1st, 2024, that's when the applicant has to be reported as well. You will have to provide, and this is the most important part here, unique identifying number and issuing jurisdiction from an image of one of the following. You will have to take an image of your driver's license, U.S. passport, and identification document issued by a state, local government, or tribe. If an individual does not have any previous documents, foreign passport. So part of the reporting requirements that you'll have to take an image or do a screenshot or a picture of your driver's license, for example, and then that will have to be uploaded to FinCEN with your application, with your reporting documents. So that's where the rub is, and that's where the contention of the lawsuit is. But this is what the government's requirement. We're required to do it. They want our IDs. They want to basically know who's behind each company and who is the person responsible, and they want to have valid ID, and you'll have to have those documents ready as well. You also need to have your tax ID number, because they'll ask for that as well in the requirements. So in terms of gathering the documents together, is not that difficult, or it's basically go ahead and getting it done. And it took me about 10 minutes to do it. It took that long to do it. And again, I'm the owner of the company, so it was simple for me to do it. But if you have a number of individuals that also own the company, so it will take a little longer because you have to get that information from them as well. For additional information, I know I kind of gave you a lot of information here today, and some of them I was not very clear. It's coming straight from the Small Entity Compliance Guide for the Beneficial Ownership Information Reporting Requirements from the Financial Crimes Enforcement Network of the U.S. Department of Treasury. And I'll have this link available in our show notes, but also on our YouTube channel, so you can download it from there and get the information. The takeaway here is that, get it done. Don't wait to the last minute. I mean, with the holidays, people may forget, and you're risking fines for not complying with a requirement from the government. It's not worth it. So get it done. There are significant penalties for not doing it. And if you have any questions, of course, check with your CPA or your attorney as well, and they might be able to provide you guidance. But as we're getting closer to the deadline, you're going to see more and more publicity and more news reports about this, and to encourage people just to get it done and not wait and not miss the deadline. It's just not worth it. So if you have any questions about any topics that I covered today, please, you can reach me at richsierra.com. My website is floridasmallbusinesslegalcenter.com. Again, floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. Our YouTube channel, you want to see this, this podcast via YouTube, you can go to youtube.com/@RichardSierra. We're on Instagram at FSB Legal. Our number is 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them, is available on Amazon, Barnes & Noble. You can ask for your local bookstores right here. Again, if you send me a legal question that I select and talk in the show, I'll send you a free copy of my book. If you like the podcast, please follow us. Appreciate a review. Give us a 5-star review. Any comments you might have, share with your friends. We're available on Apple Podcasts, Spotify, wherever you enjoy your shows. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.